Help us with thy grace to do only those things that will promote the unity, happiness, and prosperity of Nigeria. Amen. My name is Honorable Attorney Matthew Mogu. I speak for the people of Amba, Amba Criminal Constituency. I am from the state. By the name of the House, and my honorable colleagues, and the deputy chairman of this committee, sitting for the chairman, and the chairman should be here with us shortly. Before the next case, Honorable Member Kemi, can you please introduce yourself?
Mr. Chairman, honorable colleagues, our guest here present, Secretary. My name is Ibi of our house of Oka, very prosperous in the last 2 hours. Mr. Chairman, all those things will go to God.
Thank you. Next one.
Universities and refugees abducted from Nigeria and imprisoned in Cameroon. 7 summons.
Petitioner.
Present, Mr. Chairman.
Okay, can you please identify yourself, please?
Once again, good afternoon, Mr. Chairman, and we are very, very happy to be before you again today. Let me just take this opportunity to please introduce the families of the petitioners who are here with me, and to introduce one of the leaders, Mr. Chairman, who would have, if he was not lucky, would have been at the meeting where the leaders were abducted, who flew in from the United States and is with us today. Mr. Kometa, who is to my right, and counsel who is with me today is Barrister John Henry, and Barrister Achiri is not at the table, but she's sitting right behind with us. And again, Mr. Chairman, the families of the petitioners who are all in the room today, and the petitioners from jails send their greetings and their regards to the chairman. Thank you, sir.
You are all welcome. Thank you for coming. Okay, Foreign Affairs.
Chairman, sir, I will still request you to use your good office to step the things down for like 20 minutes, sir.
Have you been informed whether there has been a
Yes, it has been submitted.
Okay, this one was is here.
Yes, sir. With respect, I am Dr. Priboni Bohari. I represent the Ministry of Justice. I'm actually standing on behalf of the Honorable Minister of Attorney General and Minister of Justice and the Permanent Secretary of Solicitor General Federation.
Okay, case 2.
Okay, petition number 193 by full law chambers against Minister of Foreign Affairs. A request for help to secure the release of professors of Nigerian universities and refugees abducted from Nigeria and imprisoned in Cameroon. 7th summon.
Petitioner.
Present again, Mr. Chairman, and we are happy to be back on the record because, and just to update the record, we have Dr. Ayila.
Put on your mic.
I'm sorry. I'm sorry. Once again, Mr. Chairman, we're back to be on the record. Just greetings again from us, and to welcome.
Give me that.
Thank you so very much. To take this opportunity to welcome the members who were, the honorable members who were not here when we started. In fact, when we see, the more members we see, the more we are encouraged that we are going somewhere. That said, we want to present Dr. Yila, who's a rep here in Abuja and who gets a correspondence for us when we are not around. So again, Mr. Chairman, thank you.
Thank you kindly. Respondents.
Thank you, sir, for giving me this opportunity once again. Actually, sir, as I told you earlier, this was something related to legal issue. As the director of legal, as I told you earlier, is not around, so For me, I have no idea of what happened about this case, sir. Thank you.
Okay, listen. This is not what the ambassador told us at the beginning. He said he had the response and he on your way. And that's why we stepped it down. Ambassador said he had the response.
Yes, sir. The response we had, I don't know about this petition for this Singapore, brother. However,
Okay, have you filed your response? This is the seventh summon on this matter, and they cannot continue forever. You do what now? Speak to them.
Yes, I think with what is happening, we're going to go back and consult with our legal department and know what they are doing, because for us, we are not a legal officer. We only came here because we are only here because of that first case, the death in Singapore. We are not aware of
It's quite disheartening the way things are going. The life of people were involved. Citizens' lives are involved. They have families. I mean, let's just put ourselves in their shoes. How is it going to be? And here we are supposed to work together as a government. We have been given this document. This is not the first time this case is coming up. And here we are, the officers from the ministry don't know anything about it. It's as if we are personalizing governance in such a way that if one person is not there, then nobody can do anything. I mean, these people have been coming, have been expending resources at the risk of traveling and everything, and you people are here in Abuja. It's not fair. Charles, I suggest that since they are given that 24th, they should come on 24th. If they don't come back on that 24th, we close this case and do the deal. Please, Minister of Justice is presented with due respect to the honorable members. I am Mr. Chairman. I am just initially introduce myself. I am Dr. February Buhari from the International Comparative Law Department of the Federal Ministry of Justice. I am actually representing the Honorable Minister of Justice and the Permanent Secretary and Solicitor General of the Federation. They were both summoned in this hearing. I want to start by first expressing the profuse apology of the Honorable Minister and the PAMSEC. They would have loved to be here personally, but due to exigency of their duties, they were able to come here. And that's why I'm actually holding their brief for now. We've already filed a response to the petitioner's brief. We've already made a response to that. And I've been detailed here to read it out as is. That is why I'm here. Thank you.
Okay, go ahead.
With kind permission. Okay. With kind permission of the Honorable Chairman and members, I will proceed. No, just wait. Okay, all right, thank you. Have you been given the Ministry of Justice response?
Yes, Your Honor. Yes, honorable members. Yes.
Have you gone through it?
We have. We have had the chance to skim through it. Yes.
Yeah. Do you have anything to say in respect of that? Do you have any response?
Definitely, honorable member. After he is
No, if you are ready, you don't have to. It doesn't have to wait. That's why I'm asking you if you have gone through it. If you have gone through it, maybe there are some certain issues. They raise those issues. We cannot have you break the whole thing again when you've already had it.
Honorable member, yes, we have gone through, and we just have concerns about the arguments that are raised. Which arguments? The arguments that are raised in here, Mr. Chairman, go to technicality.
Wait a minute, get it how you live it. 10 toes in when we standing on business. I'm a big stepper.
About the case being pending at the Supreme Court. And Mr. Chairman, there are two issues that I wish to highlight to the committee. The first issue is that the issue of the appeal, there is no date as to the judgment of the two cases that are mentioned, and that date is important, Mr. Chairman, because it is from that date that we'll know when the Attorney General of the Federation knew or had reason to know that the decisions of the three federal high courts had been overturned. And the second reason is that for issues like this, that the chairman and the committee have aptly determined as life-threatening and of such magnitude that this committee takes it seriously, it really shocks us. It's really unconscionable to us that the Attorney General of the Republic would be basing arguments in this case on technicalities. And we know that the appellate jurisdiction and the Supreme Court of the Federal Republic of Nigeria has always insisted that when it comes to these matters of human rights, technicalities are brushed aside, and that the matters per se in their substance, on their merits, is what should be considered. And that if the Attorney General is actually postulating these as arguments in front of this committee, we really find it, for lack of a better term, escapist. Thank you, Mr. Chairman.
Okay, respondent.
Yes, Honorable Chairman, I just as the last paragraph of our submission, of our response is, we are totally foreclosed because we will need to draw to the attention of this honorable committee that the appeal in the Supreme Court was instituted by the petitioners. Not we weren't the ones that.
When was that?
The appeal is actually 2025. It's actually 2025. XCML 257/2025. They were the ones that appealed it. We were not. So, in which as a matter is sub judice, we all know we can't, proceed with this matter because it will be contemptuous of the court. So, that is our submission to this honorable house.
Some of our worries, petitioner, you filed this appeal when?
This petition, the appeal this appeal, to the best of our knowledge, Mr. Chairman, was sometime later this year. It's not even a month old. And that appeal was by counsel that was retained prior to the institution of this petition. When this petition was launched before this committee, there were no appeals pending. Jurisdiction from this committee vested before any appeals were carried out. Even so, Aguendoing, Mr. Chairman, what we are saying here is that we'll cede to all the technicalities that are playing out in the courts. This is a humanitarian issue. This issue is about life and death. This issue is about these families. Mr. Chairman, sitting here behind me, coming here day in, day out, with their fathers and their husbands in prison for no other reason but for the fact that They have a nationality, they have a political opinion, and they have membership in a particular social group. So we acknowledge on the record that there could be pending appeals. But that, Mr. Chairman, are trivialities. That are procedural. And like I said again, in these procedural matters, human rights takes precedence. And that is why we are appealing to this committee at this point to go right ahead and, if they can, give us a ruling one way or the other. Thank you, Mr. Chairman.
Please, let me get some clarification.
The Zenith Diaspora Banking Package is designed to enable Nigerians in diaspora take a...
The parties in this suit, are they the same parties in this petition?
Yes, the honorable member, yes.
Now, well, you briefed the lawyer to file this appeal in the Supreme Court?
Before this petition was instituted,
did you brief the lawyer to file this appeal at the Supreme Court?
our clients did in 2018, correct? But at the time when this petition was being launched here before this committee, those appeals were not pending. And it is because this petition was lodged that they then appealed the decisions that we are hearing mentioned. And thereafter, the decision that came in on these technicalities came down. And we at that point did not have a choice but to bring it to the Supreme Court because the technicalities were evoked. And case law has it, precedent has it, jurisprudence has it, morality has it, honorable members, that in these matters...
Okay, sir. The issues before the Supreme Court now has appealed. Are they the same issues that are before us here in this petition?
No, honorable chairman. The issues like are espoused in the reply from the AG are these three issues that are outlined here, which basically say that the Attorney General is not a party because they do not know the agencies, that the agencies concerned in this file are not stated, are not identified. But Mr. Chairman, honorable members, we all know that the DIA or the DSS, these are all subsets of the Ministry of Justice, which is the purview of the Attorney General. And we know that we'll go...
Now, sir, let me get this to me. If you succeed, assuming you succeed in the Supreme Court, you will not have any reason to be here. Is that true?
Yes. We will be. Honorable member, we will be. Why? Why? Because when we had those three judgments from the Court of First Instance, which were the federal high courts here in Abuja, there were 3 years between those judgments, and the Attorney General had two things to do: free these people and then go on these technicalities, because they could have gone on appeal on these technicalities. They could have done everything that they could to contact the legislature and the judicial and the executive to be able to free these people, and they did not. So even if we prevail, we are not sure that without the interference of the legislative branch in conjunction with the executive branch, anything will be done. So yes, sir, we are very sure that even if we prevail at the Supreme Court, We will still be coming back here because we will still need the weight of the legislature to liaise with the executive to be able to have this resolved. Thank you, sir.
Our worries in these matters is when parties try to divest jurisdiction once acquired by the National Assembly. I don't know whether it is as a result of no scheduling orders in the Federal High Court or Court of Appeal, where you have time to appeal decisions. Somebody has to wait 5 years, 3 years before you appeal. And when the matters are here, they rush to appeal in order to divest the jurisdiction. This House does not take that kindly. But now, this appeal, petitioner, you are the one that instituted this appeal to the Court of Appeals. Supreme Court, I'm sorry. That is a worry. Though you know your matter was still pending here, and that your client may have briefed a lawyer to institute the appeal, but you still came here. So that alone is troubling for us.
GoDaddy has the perfect hosting plan for any website, from low cost.
Mr. Chairman, without making sure that I could never speak over the chairman, I want protocol to realize that I would only speak when I have to speak.
Go ahead.
Mr. Chairman, there's a representation that I think is not well done. We did jurisdiction vested with this committee before any of these appeals were filed. And like you say, it's causality. They filed an appeal against something as fundamental as this. And the argument of the appeals court was on technicalities. And Mr. Chairman, as a lawyer sitting here, I'm advising my clients, we cannot allow the deadlines to expire without filing this appeal, just in case. But Mr. Chairman and honorable members, we know what we are talking about here. We know that the lives of these people are at stake. We know that families are suffering. We know that Nigerian students are missing their professors. We know all of this. We know that in terms of economic, pecuniary value, we are missing Nigerians. And we are coming here. These technicalities, we could resolve them in the courts. But in terms of the substantive matter here that has to do with the release of those people, that is why we are in front of this committee. That is why we are in front of the legislature. That is why we intend the legislature to liaise with the executive for something to happen. Thank you, Mr. Chairman.
Okay, let me ask you this. What is the relief are you seeking at this point? What are the release before this point?
Simple, honorable member. We are just asking the judgment of the Court of First Instance, which is the three high courts in Abuja, to be maintained. By the way, there's another technicality that they are not mentioning. There are three different judgments. There have been two of the judgments. One of the judgment is still pending, and the facts, and one of the petitioners is a petitioner in here, Dr. Ogo. His case, somehow, by divine providence, was never appealed. So, as they are bound to hang on technicalities, that is a technicality that they cannot escape from before this committee, because that case has not been appealed, and we will be asking this committee on the basis of that link to make its findings and its rulings based on that case that was not appealed. And that case is in the record already, We've already presented it in the record, and it is there, and the name of the petitioner, I've already given it to the committee.
Council, I think we are missing a point. Most of these judgments are in your favor. And you are talking now about a judgment that has not been appealed. And that judgment, I presume, is in your favor.
This is Pod 5, the first fully immersive sleep system. Intelligent.
Correct.
You came in here now for us to intervene. But instead of allowing us to intervene, you now went to the Supreme Court. The judgment that you have, you can enforce your judgment anytime, any day. It's your judgment. You go back to the court as a counsel and ask for enforcement. But I have pity about what is happening. It's quite disheartening. People are being wasted away. But what you have done is to tie our hands behind our back, not to act. That's why I was asking you those questions. Because of this case that you have now gone to Supreme Court. If you are going to Supreme Court now, what do you expect us to do? We give our own opinion here, take it to the House, and we pass a resolution, and then what will the Supreme Court do again?
Honorable member, without belaboring the point, I just want for emphasis to state that this petition, we did not go to the Supreme Court and then come and file this petition. We filed this petition.
We understand that, but you have made it quite clear. Quite clear. Your petition was here before you. Now, take the appeal. So in essence, it's like, okay, here they are delaying me, I'm going to get the first address.
So, Honorable Chairman, conceding there's nothing better than recognizing a technicality, and conceding there's nothing better than recognizing a technicality and standing on it. Let's concede that two of these cases have been appealed and that they are pending. There's one of the cases. One of
okay,
the
let's there are many matters that we are they are waiting. I have not seen the. Can you avail us with the copy of what you filed at the Supreme Court? You cited this. Can you get us a certified true copy?
I can liaise with the clerk.
Get us a certified true copy. When we come and see that thing, we will take a decision that day. Thank you.
Okay, sir. How long will it take you to get this to us?
The certified true copy. I don't know if I already have with me here. Maybe if they want to make a copy from it, if that will be okay. I have a certified true copy of all the cases here with me. We already have them.
The petition
The Supreme Court, yes.
is certified to copy.
Yes, certified true copy that we obtained from the court.
Or you give us. Let me see first.
Mr. Chairman, sir. Mr. Chairman, with all due respect, I have counsel here has some information that she wants to share with the committee. With your permission.
Yes,
Go ahead.
Sorry, Mr. Chairman, the petition Ministry of Justice is trying to reduce that just an application for extension of time to 5. The process proper has not been filed. That application is for extension of time at the Supreme Court.
Yeah, I understand, but it's supposed to be fact-checked.
You attach the documents.
Yeah, it's behind.
Once it is granted, it's been filed.
Yeah, it's behind. Huh?
Okay, this matter is set for July 24th, 2025.
Mr. Chairman.
I'm sorry.
Mr. Chairman.
We
do not have input from us. We come a long way for this, Mr. Chairman. And from the 24th, Council will not be
September. No, July,
September. And
if you are not going to be present, you can send one of your juniors.
And Mr. Chairman, we really, on the record, want to make this appeal to the committee.
If you are saying off the record, off your mind.
Okay. Well, let me put it on the record. It's an appeal to the committee that we would love finality on this, one way or the other. So we would suggest that the 24th be a firm date so that we have a lot of issues to be able to address in terms of appearing numerously and severally. That appeal, as coded as it is, we would love to really stress that as a right of procedure that we have a firm date on the 20th in September. Thank you, Mr. Chairman.
We agree with you. Okay, it's a firm date. Respondents take notice. And they can wait to get your summons now. After this year. Okay, it's a firm date. Respondents take notice. And they can wait to get your summons now. After this year.
Thank you so very much for giving me the opportunity to do this after session. Thank you so very much for giving me the opportunity to do this after session debrief, which is one of its kind because this is the first time that we are actually having a session debrief. And before I get into that, let me seize the opportunity to introduce to my right Ernest Cho, who is the resident representative of the refugees here in Abuja, and Dr. Yila Akwedal, who is a lawyer representative here in Abuja, because he's not a lawyer, but he has been so much part of the case that he represents us, and because of his employment with the National Assembly, he acts as an able liaison between us and the National Assembly. Apart from his very deep personal and emotional attachments to the leaders in jail, we want to really recommend him and thank him, and on behalf of the Amazonian prisoners of conscience, and especially Sisekwa Yoktabe and his group of 9 brothers, I really want to thank Dr. Yila for hanging in there with us, for doing everything possible to give us the connections that we have in the National Assembly, and to be able to always be there when duty calls. In fact, he came in from Gombe just 2 days ago just to be at this hearing, and he has done that for all these other 7 hearings that we've had. So it's really worth commendable that we have a brother like this. We have an Amazonian friend like this who can hang in with us, stand with us, and really bear with us. And especially Professor Wasum, who was his professor, and who is a personal friend and brother to him. And on their behalf, and on behalf of Sisekwa Yoktabe, I really want to thank him and to tell him that, like the leaders will say, he is really recognized, and at the appropriate moment, they should be able to tell him that in their own words. That said, I think there were others who are not present with us here. There was Barrister Njong, who was at the hearing, and Barrister Achiri, who was also at the hearing. There is one of the leaders who came in, Mr. Kometa Elvis, he was at the hearing. And then we have other resident friends and family who were there and who cannot make it to this debrief. To all of them, I extend the gratitude and the appreciation of the leaders in detention, because it's through their appearances and through their numbers that the parliament, that the National Assembly can really appreciate what toll this is taking, what emotional toll this is taking on families. All the families cannot travel here all the time, but you know that their families scattered all over, whether it's in Zaria or Kano or in Bayero, all their families all over who would have been here, but because of the expenses, they cannot make it all the time. But for the families that were here as well, I really take this opportunity to thank them on behalf of the leaders in jail as well. So that said, let's get into the brief proper. Today was an extraordinary day. The new chairman and his deputy, like they indicated from the last hearing, bent on really getting resolutions to this. So they had there were filings from the Attorney General as represented by the Ministry of Justice, and they had submissions. Foreign Affairs, as expected, came in again and said that their legal representative was not around, and so their submissions were not in. And of course, for those who were in the hearing, the committee really frowned at that, and they didn't take that lightly. But what was most important and what is salient about this session was that it came out from the submissions from the Justice Department, as presented by the Attorney General and the Secretary of the Justice Department, that the same cases have been appealed to the Supreme Court, and because of that appeal, the principle of sub judice sets in. And sub judice basically means that
another arm of government or another agency of government cannot interfere when a case is actually pending before the courts, before the judicial system. And because this case is now pending before the Supreme Court of the Federal Republic of Nigeria, Parliament, as represented by the National Assembly and its Committee on Public Petitions, finds it difficult to be able to rule on that. There are issues that we'll have to espouse, and they've given us the opportunity to be able to lay out these issues, and I should be able to, with my team, sit and espouse these issues and lay them out in a memorandum that we'll present to the committee. That said, if there are specific questions, we would like to answer them, or if there are specific issues that you want us to outline, we will do that. Thank you. Yes, the next hearing was actually scheduled for the 24th. It was supposed to have been scheduled for the 24th of October, but my team was not actually going to be available. So we asked, no, they said the 24th of July, and that was not going to be available for us. So they gave us the 24th of September. I'm sure that August, they are not really open. So 24th of September is the next hearing date. Southern Cameroonians, aka Ambazonians, have been waiting for this. They've been following up this hearing with a lot of interest, as it should be. And we are saying that in spite of this legal development, we have an opportunity now to be able to espouse these issues in a very conventional way to the committee. And so there are jurisdictional issues now, if at all, because the details of that was that in law, whoever alleges has to prove. So the Attorney General came in today and said, this case is pending before the Supreme Court, and proffered evidence just of an extension that has been requested from the Supreme Court to be able to file. But that in itself is an intent to file already. And so the court requested that they should bring certified proof of that has happened for them to be able to act on. And then they, of course, now that we know that this is what is that we're facing, we should be able to gather our facts and the law to be able to put the legal memorandum together and file to be able to counter that. And so at that hearing, the expectations are that the committee is going to consider the evidence that they provide, and then consider the legal arguments that we're going to file, and come to a valid decision. And just in case, the principle of sub judice steps in, which says they cannot actually, jurisdiction will divest once they have concrete proof that this case is pending at the Supreme Court. Then all they will do is wash their hands off the case, because they cannot handle it while it is pending at the Supreme Court. And even if that happens, no matter what happens at the Supreme Court, we will be coming back to them, because one of our major arguments is that, because it came up in the hearing that the chairman actually asked, if the Supreme Court rules in your favor, will you be coming back to the committee? And my answer was a resounding yes. We will be coming back, because, after all, the three High Court judgments were sitting there for over 3 years, and they were not acted upon. And that's why we came to Parliament in the first place. So we are saying that even if the Supreme Court rules and there's no political will to be able to execute it, we are still going to come back to Parliament. But hopefully, if the Supreme Court rules in our favor, we are going to, we are not going to come back there. Or if we are going to come back, it will be for policy reasons, to be able to push them to be able to make some policy decisions. But what is important here for Ambazonians to know is, number one, that the appeal at the Supreme Court is on technicalities. and the Supreme Court of Nigeria and the appellate jurisdictions has been very clear as to what happens with human rights violation cases. The court, in its jurisprudence, is very clear that when it comes to these matters, the matters of human rights violations, what is sacrosanct and what is important, what is primordial, is the substance of the issues, whether rights of Nigerians or citizens have been violated. And here it is clear as anything can be, that these rights have been violated. The Supreme Court of Human Rights has already ruled on that these laws have been violated. If they're pinning their hopes on something as trivial as a defective affidavit, it does not cancel out the fact that agencies of the federal government carried out these abductions and that they were locked up, all right, or kidnapped and stored away in the premises of the federal government of Nigeria, and that the agents of the federal government of Nigeria participated in the refoulement, in the handing over of this petitioners back to a government that had persecuted them in the first place. Because that's the basis of this petition. The petition is basically asking Nigeria to account for the fact that they could blatantly violate the 1951 Refugee Convention that says once somebody has given you a prima facie evidence of being persecuted on the account of his race, his religion, his nationality, his membership in a particular social group, or his political opinion, you cannot send them back to that same arm that they are fleeing. And the appeal at the Supreme Court does not say that this did not happen. The appeal did not say that this did not happen in Nigeria. The appeal is arguing frivolously that one of the affidavits that was proffered to support this point was given by a functionary or an employee of one of the law officers, which is the general practice in the jurisdiction. And so whether this comes out, whatever way it comes out on, we are on a good footing, and we think that this the rights and the fundamental rights of these petitioners, of these leaders, of these men have been violated, and we would go to the end of the world to be able to vindicate them. And I think that Parliament is open to that. Parliament saw the facts, and they should be able to follow in the steps of the Working Group on Arbitrary Detention that did the right thing and asked them to be released and be compensated. Thank you.
Una don watch wetin wey e pass for inside Nigeria House of Representatives. That is, of course, deliberations on the illegal detention and violation of the law of non-refoulement of the rights of the people of Southern Cameroon's Ambazonian leaders in detention, Naira 10, if you want to call it. These are asylum seekers and refugees who are residing in Nigeria, some of whom are even Nigerian citizens, already acquired citizenship. This particular incident took place on the 5th of January 2018. A high-level mafia that took place between La République du Cameroon government, supervised by Paul Biya, and then Muhammadu Buhari, who is of late. We are just saying that it is time for the right things to be done. These deliberations, of course, will center around one thing: a resolution will be passed, and it will always be in favor of Southern Cameroon. But better still, I want to just say, our people, we have to continue pushing. These efforts were not just done haphazardly. Some people had to put in heavy sum of money to ensure that the logistics of those lawyers, their welfare, well-being, the time going there is being taken care of. Please, I want you people to applaud those who are working behind the scene to ensure that such initiatives are being taken ahead, because La Republic du Cameroon panics. Their names get dirty when things of human rights abuses come to a limelight. On those who were, of course, there in Nigeria to look into this issue as well, we are looking at special thanks to you, Ambazonia, Zozo, Chase Candy, and all the like, Comrade Cho NS, and many others. Not forgetting the indefatigable and powerful through law chambers that has taken up this matter as a personal one to ensure that justice is done to the people of Southern Cameroon. Thank you so much. Thank you for your efforts. Thank you for your sacrifices. I am Fabiano Deco. I bring to you updates from this end that took place on the 10th of July 2025. We'll be monitoring the situation to bring you details about this. Without much ado, justice must be done. Injustice anywhere is injustice everywhere. We stay keen. We continue to keep our eyes on the ground on this particular issue, and we assure our prisoners of conscience, we assure our people that for sure, definitely, God has not abandoned us. God is with us. La Republic du Cameroon will be put to shame and justice will be done. Thank you very much. I'll see you again in our next update.